Hi, I'm Zara. I'm an appellate attorney. I represent clients and I also write briefs as of counsel to other attorneys for appeals in cases that are pending in federal, state, and the immigration courts. I wanted to talk today about a piece of advice that I think every lawyer right now should be thinking about during this pandemic. Now, at the beginning in March, things were changing so quickly that we were all basically getting whiplash. There was a new order or a new notification coming from the courts and from the governor just about every hour. And I'm sure all of you have had to digest these and figure out how they affect your clients. And I'm sure it's affected the way you've been advising your clients and what they should do and how they should handle their affairs going forward. All of you have will have a different um, experience of this, and we'll be dealing with it on a different level. But I'll give you an example of what I'm talking about. I've seen a lot on social media and in different listservs where I correspond with other lawyers about the real estate closing market in particular. Now, when the lockdown order was issued in New York, there was all of a sudden a big question about how clients could close on the sale of their property. Now, all attorneys have been handling this a little bit different. These sale of property is under contract, and time of the essence letters have to be issued in order to preserve rights under the contracts. But at the same time, many clients, understandably, did or do not want to appear in person for closings, and everyone is encountering different situations, different variations of this situation. And one of the things I've told some of my colleagues who are real estate attorneys is to make sure that they are carefully documenting the reasons for the advice that they're giving their client with respect to whether they should appear, whether they should demand an adjournment, whether they should send the time of essence letter, whether they should reject the time of essence letter, and any number of variations of this same situation. Now, the reason I'm telling you this is because later, hopefully this doesn't happen to you and your clients, but at some point, some of these cases will end up in litigation. And at some point after that, say 5, 6, 7, even 8 years down the road, they will end up in the appellate court. And when these cases land before the appellate judges, who often take a very academic and cold look at the facts in the record, it will be very hard to persuade them with a compelling narrative about exactly what was going on in this moment, because everybody will have forgotten the urgency of this time and how hectic and chaotic it was. And the more you document now, in your own notes, in your letters to your clients, in letters to opposing counsel, the more you put details of what is going on factually and emotionally with your clients and the decisions that you need to advise them to make, the more detail you have in affidavits and motions, the more detail will be in the appellate record, and the easier it will be for an appellate attorney like me to help you or your client create a persuasive reason for the decision that they made in this time. Now, hopefully you are already taking that advice, and if not, you should start now. Start collecting different news stories and notices and really writing down the reasons why you're giving the advice that you're giving to your clients right now. And also, I'd love to know from you which of these changes and restrictions and other orders have affected you in your particular practice area. Can send me an email. I'd love to hear from you, or you can just leave a comment in the box below and tell me, so that I, as an appellate attorney, can be ready to reconstruct these chaotic times when it's time to present the stories of what's happening here to the appellate judges. Thanks for listening. And again, I'm Zara. I'm an appellate attorney, and I handle cases in the state, federal, and immigration courts.